Nigerians should know that issue of secret trial of former AFCC acting chairman is unknown to our law. Why? Because the allegation borders on corruption charges, conspiracy, abuse of public office, and other infraction does not fall within the exception known to law. Therefore, it is a great injustice to Nigeria to allow such allegation bordering on abuse of public office to be tried in secret. In fact, the law allows us to see that the hearing is taking place in public and not secret trial. It against aggravation of criminal justice in Nigeria. It is commonly believed all over the world that so far you fight corruption, it will definitely fight back, and that is what is play in Nigeria now. And Nigeria are worried. Why Nigeria are worried is that they are worried about the caliber of the witness, their conduct, especially those who issue statements in public in respect of the proceeding. That is why Nigeria are worried. Nigeria are also worried as to the nature of prayer before the tribunal. Of course, tribunal does not have power to grant some of that prayer. Also, that prayer is done within the time of reference given to the tribunal. It is unlawful and absurd for the tribunal to review cases that are pending before the Superior Court of Records, such as Federal High Court, Court of Appeal, and Supreme Court. It is not fair, and that is why you will agree with me that corruption usually fights back. Generally, the tribunal has power to summon and examine witnesses to come and testify against anybody. However, our worry is the conduct of the people who came to testify. Some of them are lawyers to the suspect. Some of them are aggrieved members who want to take back their money and things like that. The problem with the EFCC is the nature of their activities. Generally, people don't want the whole truth, and the African Nigerians are corrupt. Most of the people in the authority, they have corrupt tendencies. That is why anybody who is charged with the responsibilities of anti-corruption war will always be a victim. I know as a common belief that corruption will definitely fight back. And that's what we are experiencing currently. In a situation like this, we need to go back to our constitution. We need to respect the word and contents of our constitution and all other enactments of National Assembly. What is going on right now does not reflect true procedure in administration of criminal justice in Nigeria. In discussing the true procedure of administration of criminal justice in Nigeria, we have to consider the rights of a defendant who is starting trial. For instance, if any person is charged for an offense, is entitled to the following. One, a defendant who is standing trial is entitled to know all the details about the allegation against him. First. Secondly, all the facilities that may be relied upon by the prosecutor must be given to him beforehand, before the commencement of proceeding against him. Equally, it is important to say that the defendant who is standing trial should have an opportunity to cross-examine all the witnesses testify against him. It should not be shortchanged in that direction. It should be given opportunity to ask questions from the witness. Failure to do that is an infraction. It's an infraction against the defendant's rights. It's an infraction against the Constitution, and it does not represent true procedure of criminal trial in Nigeria. If what we read in the social media are something to go by, one can conclude that failure to forward all the relevant documents, such as the petition against him, such as the instruments from the president, and the charges against him were not given to him within a reasonable time. The implication is that one can conclude that the defendant was not given adequate time to prepare for his defense, because I'm aware that the aims and objective of criminal procedure is to see that justice is done to all the parties. In this context, justice must be done to the defendant to ensure that he has every opportunity to defend the allegation against him on merit. Failure to do that is an infraction of Section 36 of National Constitution, who provides for defendant that he is entitled to fair hearing, and that the law presumes that he is innocent until and unless the court of competent judicial prove otherwise. My advice to the president is that he should come closer to the people to know what is going on. As father of the nation, as a person who brought and championed the anti-corruption war in Nigeria, to look into this matter critically. I'm very sure the president was not aware that the trial is being done contrary to the dictate of law. the procedure is not in the constitution, and therefore it should not act strictly on the recommendation from the panel, who has denied the defendant, has failed to give him fair hearing. He has failed to give him a reasonable time to defend himself. Nigeria's worry is that how could a tribunal forget so soon to give a direction that all witnesses shall be on oath as provided for by section 5 and 6 of the Act. If all the member of tribunal must be on oath, why the tribunal fail, refuse, and neglected to administer all the witnesses on oath? Not only that, the defendant was not given opportunity to cross-examine the witness. It is totally unfair and does not represent the position of law. My opinion on that: we were reliably informed that the petition emanated from the Attorney General of Federation Office triggered this issue that prompted the President to constitute this Judicial Commissioner from Kari. However, the Attorney General of Federation has discretion and power to write a petition in respect of public issues. However, what we are saying is that due procedure must be followed, and that it should be seen as impartial party. For example, one of our colleagues issued a statement that he was arrested because he failed to testify and implicate the defendant. Though we have had contrary opinion that it is not that. Some other people were of the opinion that it's a wish hunting. Those are the messages and information we had and read on social medias. I want to suggest and implore the panel to invite Attorney General of Federation to summon him as a witness to come and clear the air, because most of the witnesses brought forward as disappointed Nigerians. They are people that has personal interests and personal grudges against the defendant. The duties and obligation of lawyer is to promote justice, to foster unity, and speak the truth at all time. In discussing corruption cases or corruption matter in Nigeria, is a collective fight. It does not for the lawyers alone to fight corruption or to ensure that justice is done at all stages of proceeding. My advice to the lawyer in public practice is to see that justice is done at every stages of proceeding and not other way around. Nobody is above the law. And we are all yearning for a clean society. We want our society to be free of corruption. So, and we support fighting against corruption. But what we are saying is that let there be justice. Let there be justice to the defendants, and we don't want a selective fight against corruption. We want a total fight against corruption.